Hello, thank you so much for pressing on this video. My name is DELPHINE AKINSETE and I am a solicitor at DELPHINE Philip Law. Today I'm going to be talking about termination of a tenancy agreement by a landlord. There are different ways that a landlord can bring a tenancy agreement to an end, but I'm going to be paying more attention to a landlord gaining back possession of their property. I'm going to be concentrating more on Section 8 because we've had a lot of cases recently on Section 8. Also because Section 21 might be a bit more straightforward. If you want me to talk about Section 21 in another video, please be sure to leave a comment below and I will definitely make a video about Section 21. Before I go on, I want you to understand that even though I am a solicitor, I am not your solicitor. I only become your solicitor when you instruct me, and I am happy to be your solicitor. And details will be left for you to be able to contact us if you need our services. So you get independent legal advice if you want to clarify anything that I say. And whatever I say is not really peculiar to your circumstances. It's not really particular. It is just a general brief I am giving, general guidance about Section 8 claims. Now, a landlord's options as to how to terminate an assured short-hold tenancy are largely constrained by the provisions of the Housing Act 1988. There are two main routes, based on the Housing Act 1988, and you can go through the Section 21 or the Section 8 route. Like I said, I am going to be concentrating on the Section 8 route. Section 8 has discretionary grounds and also mandatory grounds. So it's better and it's important that you understand what grounds you want to get your tenant out on, or if you're the tenant, you understand what grounds your landlord is attempting to or has gotten you out of the premises on. Ground 8 is based on arrears, and this is a mandatory ground. If you are in arrears of 2 months rent, your landlord is going to get you out of the premises on mandatory grounds. If your tenant owes you more than 2 months rent, then you can make an application for possession to the court to get them out on mandatory grounds. One of the most commonly used grounds is the mandatory ground. However, there are other grounds that also have to do with rent arrears. The landlord can serve a valid Section 8 notice relying on grounds 8, grounds 10, and grounds 11. But like I said, grounds 8 or ground 8, if you want to call it that, is the mandatory ground. To prove the ground 8 or to prove ground 8, the landlord or landlady must show that there are at least 2 months arrears. Both, 1, at the date of the service of the Section 8 notice, and 2, at the date of the hearing. And that is where a lot of landlords have an issue with getting back possession of their property, because the 2 months arrears is not just 2 months arrears. There must be 2 months arrears owed to you as a landlord or landlady at the date of the service of the Section 8 and also at the date of the hearing. This means that as a tenant, if you owe 2 months rent at the time that the notice is served on you, if you're able to clear the 2 months rent at the time of the hearing, then your landlord would be unable, or most likely, because there are other grounds that your landlord can rely on except for ground 8. However, if he is relying or she's relying solely on ground 8, which is a mandatory ground, and they are less than 2 months rent, then it is unlikely that the judge would ask that you leave the property outrightly. The judge is able to ask that you leave the property, thereby giving possession to the landlord or landlady in different ways. The judge can ask that you leave within 14 days of the court judgment, or in exceptional circumstances, and I can talk about what constitutes exceptional circumstances in another video. If you leave a comment below and say you want to know more about what constitutes exceptional circumstances, the judge can actually extend or suspend the possession order for 42 days to allow you enough time to be able to leave the property. Now, for the judge at court to give a possession order to the landlord or the landlady, the court must be satisfied that 1, if rent is payable weekly or fortnightly, at least 8 weeks' rent is unpaid. If the rent is payable monthly, at least 2 months' rent remains unpaid. If rent is payable quarterly, at least 1 quarter's rent is more than 3 months in arrears. And the 4th one, if rent is payable yearly, at least 3 months' rent is more than 3 months in arrears. The need for the court to be satisfied as to the amount of the arrears is a very strict requirement, and satisfying the court that rent is due can be done in one of 3 ways at the hearing. So if you represent yourself as a landlord, or if we as solicitors represent you, there are 3 ways that we can show that there is actually arrears that are being owed. The first one is solicitors, or you as landlord or landlady, can give oral evidence at court to say this is how much rent is being owed. The problem with that is if your tenant says that is not how much is being owed, then you have nothing to fall back on, because when you go to court, you have to go with evidence. The court always wants to see written evidence, because if it's just oral testimony and the other party here being your tenant decides that they do not agree with your own calculations as to how much rent arrears are owed, then you have a problem. The second way is by us as solicitors acting for you, or you as landlord or landlady producing a document which is shown to form part of the records of your business, so you can produce a rent schedule. As solicitors, we always go for a rent schedule because we're talking figures, so we want to make sure that the judge can see the additions, the subtractions, when rent was paid, if you're getting any benefit like housing benefits, when the money comes in. It makes it very easy at court, and it just means that you save your time and you save the time of the court, which is what we call the overriding objective. The next one is by the tenant admitting the arrears. It's not always the case that the tenant admits the arrears. If they were so willing to admit the arrears, many of them would not be in court. They would actually move out of your premises as landlord or landlady even before the court date. But it is possible, and yes, in court you have to tell the truth. So the judge can ask the tenant if they actually owe a particular amount. The problem is sometimes you have a figure that is, say for instance, £10,493.07. That is a figure that the tenant might not be willing to agree to because it's not a rounded up figure. So the tenant might know that they owe about £10,000, but what about the pennies? you then waste the court's time, you waste your time. So as solicitors, what we do is we make sure that you have a bundle before the judge, even before the hearing, at least 7 days or 5 days. We follow the practice directions. Just depends on the case and it depends on the court order. And we make sure that you have all the necessary legal documents. We make sure that your quit notice is served properly.